to bring many of the wonderful speakers that the Jackson Center has so kindly brought to our community to also participate in our roundtables. This morning's speaker, I'll be introducing Greg here to introduce him. This is not, I believe, Professor Hockett's first visit to JCC. In fact, our own Greg Rabb was involved with a visit that Professor Hockett made 1992. So we're thrilled to have him back. But to introduce Professor Hockett this morning, it's a great pleasure to introduce our good friend from the Jackson Center, Mr. Greg Peterson.
Thank you, and thanks to Jamestown Community College, and thanks to Greg DeCinque, Greg Rabb, because it was Greg Rabb through a grant which brought Jeff Hockett here back in 1992, celebrating the 100th anniversary of the birth of Robert Jackson. This year at the Robert Jackson Center, we are commemorating the 50 years since he died in 1954, and as part of that commemoration, we've had certain events. And Jackson's life really revolves around two central focuses. One is his days at Nuremberg. So earlier last month, October 1st, we had one of the Nuremberg prosecutors, Whitney Harris, here to talk about that period of Jackson's life. October 3rd, we had a commemorative service at St. Luke's Church whereby we commemorated the fact that his death and his funeral was at St. Luke's, and all 8 justices of the United States Supreme Court came to Jamestown, which was unprecedented, and it's likely that'll never occur again. And the other part, of course, of Justice Jackson's life is the fact that he was a Supreme Court justice for 13 years and was involved in many of the seminal decisions that we study today. To help us focus in on that period of his life, we have Professor Jeffrey Hockett. We're honored to have Professor Jeffrey Hockett for several reasons. You should know that there's not been a lot written or published on Justice Jackson, and in fact, there's only 4 books on Justice Jackson. Eugene Gerhard, who wrote the only biography in 1958, Professor John Barrett, who included in that book, which was published last year, called That Man, which is really a manuscript by Robert Jackson on Franklin Roosevelt. There was an awful lot of biographical information by Professor Barrett. There was also, way back in 1960s, a gentleman who put together a book on behavioral studies and talked about Justice Jackson. And the 4th book, New Deal Justice, the Constitutional Jurisprudence of Hugo Black, Felix, Frankfurter, and Robert Jackson, authored by Jeffrey Hockett. We're thrilled to be able, as we attempt to fill out the mosaic of who Robert Jackson was, to have Jeff in our midst. Who's Jeffrey Hockett? Associate Professor of Political Science at the University of Tulsa, received his doctorate from the Department of Government and Foreign Affairs at the University of Virginia. He worked with Professor Henry Abraham, and for those who were here last year, Professor Abraham came up from the University of Virginia to talk about Jackson. He's the author, as I mentioned, of New Deal Justice, the Constitutional Jurisprudence of Black, Frankfurter, and Jackson. Is the recipient of several research fellowships, including a National Endowment for the Humanities Fellowship for college teachers and independent scholars, and an Earhart Foundation Fellowship research grant. His article, Justice Robert H. Jackson and Segregation, a study of limitations and proper basis of judicial action, received a Hughes Gossett Memorial Award for Excellence in Historical Research from the Supreme Court Historical Society. He's the recipient of several teaching awards from the University of Tulsa. His current research focuses on the Supreme Court's 1954 desegregation case, Brown versus Board of Education, which of course we were glad to celebrate that last year. And his book manuscript, A Storm Over This Court, Attitudes, Institutions, and Brown versus Board of Education, is currently at press to be being reviewed. Today, we're thrilled that he's going to share with us on the subject of Justice Robert H. Jackson and segregation, some reflections on the 50th anniversary of Brown versus Board of Education. I'm honored to introduce Professor Jeffrey Hockett.
Thank you very much, Greg, for that introduction. And let me begin by saying that it is a pleasure to visit Jamestown once again and to have an opportunity to speak about Robert Jackson. And I thank Jamestown Community College and President DeCinque for the invitation, and it's great to see Greg Rabb once again. And I also want to thank Greg Peterson for the hospitality. It's been wonderful. And I have to say it's been a pleasure to learn more about Jamestown, and in particular the diversity in baseball loyalties in this city. I mean, it's pretty remarkable. I was told, I'm from Chicago originally, and a diehard Cubs fan, I'm sad to say. And I was told that there are a number of Cubs fans in Jamestown, and not just that, but Yankees fans and Red Sox fans. And I want to take this opportunity to thank the Red Sox and the Red Sox fans for beating the Cardinals, because as any Cub fan will tell you, the next best thing to the Cubs winning is the Cardinals losing. To Yankees fans, I like to say that I feel your pain. Believe me, I've had a lot of experience with that. And then to those Cubs fans out there, I also want to ask why. Why you would root for the Cubs when you didn't have to. I don't understand why you would set yourselves up for that, but I appreciate it. But anyway, I'm especially glad to have an opportunity to speak about Justice Jackson during the 50th anniversary of one of the court's greatest decisions, and a decision in which Jackson participated, the historic desegregation ruling, Brown versus Board of Education, which was decided in 1954. Now, in this talk, I focus upon Jackson's approach to the segregation controversy. That is, how he came to conclude that the practice was unconstitutional. And I contrast his approach with that of Chief Justice Earl Warren. And as you probably know, the Chief Justice was largely responsible for the argument in the final unanimous opinion in Brown. Now, the ruling in Brown that racially segregated public schools violate the Equal Protection Clause of the 14th Amendment has rightfully become one of the most celebrated decisions ever rendered by the Supreme Court. And we should recall, however, that when announced, the form as well as the substance of Warren's opinion drew bitter criticism. Even certain liberals challenged the opinion's form. They appreciated the result, but the form was criticized by left and right. Now, recall that the opinion said that the separate but equal standard established in Plessy versus Ferguson, decided in 1896, must be abandoned in public schools because separate educational facilities for the races are inherently unequal. And Warren invoked a number of social science studies to demonstrate the psychological harm that segregation inflicted upon African American children. The apparent lack of a legal basis for the ruling and Warren's reference to sociological studies struck many, including certain scholars who opposed segregation, as evidence of a policymaking court. That is, it was regarded as an instance of judicial usurpation of the legislative function. While the form of the opinion was not the primary reason for the protracted noncompliance that followed the ruling, I would argue that the misgivings that the court's argument engendered exacerbated the vulnerability of the ruling. My thesis is that many of the criticisms leveled at Brown could have been avoided or at least blunted had the court followed Justice Jackson's line of argument for this case. Jackson's working papers for Brown reveal that he possessed a certain prescience concerning public reaction to judicial attempts to depart from long-standing constitutional doctrine. His careful attention to the inherent limitations of judicial efforts to reform society and his attention to the informal restraints that public opinion places upon those efforts resulted, paradoxically, in a sounder approach to securing the rights of the plaintiffs in Brown. Jackson suppressed his opinion in the interest of Supreme Court unanimity and because of his debilitated condition following his heart attack of the same year. Now, the first section of Jackson's memorandum provides a brief discussion of the complexity of the situation before the court. He noted that the eradication of segregation involves nothing less than a substantial reconstruction of legal institutions and of society, because racial separation, as he noted, is established in the laws of 17 states and is embedded in the social customs of a large part of the country. And Jackson maintained that the Southern situation is complicated by antagonisms toward African Americans that do not exist in the North. The white South, he said, still resents the program of Reconstruction and the humiliation of carpetbag government. And Southerners linked black Americans, the professed beneficiaries of Reconstruction, with all that was suffered at the hands of the North. So consideration of the conditions that brought about and sustained segregation, Jackson said, should deter the court from adopting a pharisaic and self-righteous approach to this case. Jackson turned in the second part of his memo to the question of whether existing law condemns segregation, and I quote, "Layman as well as lawyer must query how it is that the Constitution this morning forbids what for 3/4 of a century it has tolerated or approved. He must further speculate as to how this reversal of its meaning could have been initiated by the branch of the government supposed not to make new law, but only to declare existing law, and which has exactly the same constitutional materials that, so far as the states are concerned, have existed since 1868, and in the case of the District of Columbia, since 1791. And Jackson went on to admit that several considerations appeared to support the notion that segregated schools were constitutional. Starting with the language of the 14th Amendment. He said the language does not furnish a definitive basis for outlawing segregated schools. Why not? So his point was that the 15th Amendment was required just to assure equal voting rights to African Americans. And in spite of the obvious deficiencies of the 14th Amendment's Equal Protection Clause, the 15th Amendment included no language referring to either segregation or education. Moving to historical analysis. He argued that historical analysis reinforces the view that the 14th Amendment does not provide or prohibit segregated schools. He argued that if deeds are consulted as evidence of purpose, the behavior of neither Congress nor the states indicates that the 14th Amendment prohibited segregation in education. The very Congress that proposed the amendment, and every subsequent Congress, maintained segregated schools in the District of Columbia. And 9 northern states continued or established segregated schools after ratifying the 14th Amendment, while all 8 reconstructed states instituted segregated schooling. Case law also supports the view that segregation is constitutional. Indeed, Jackson pointed out that almost a century of case law confirms this view. An examination of the language, the history, and the case law of the 14th Amendment led Jackson to conclude, and again I quote, "Convenient as it would be to reach an opposite conclusion, I simply cannot find in the conventional material of constitutional interpretation any justification for saying that in maintaining segregated schools, any state or the District of Columbia can be judicially decreed up to the date of this decision to have violated the 14th Amendment." In the third section of his memorandum, Jackson focused on the difficulties attending the enforcement of a judicial decision invalidating segregation. The court, he noted, lacks the power to enforce decisions of law by applying sanctions against persons not before it in a particular case. Furthermore, the school districts, he argued, can be expected to continue segregation without the aid of legislation because racial separation exists as a local usage and deep-seated custom. If the court must rely upon its own resources, he warned, a decision invalidating segregation is likely to bring the court into contempt and the judicial process into discredit. Any constructive policy for abolishing segregation, he said, must come from Congress, because the power of that branch to implement its decisions far exceeds that of the court. While Jackson devoted most of his opinion to an examination of the difficulties attending the execution and justification of a decision invalidating segregation, he explained in the final section of his memorandum why the constitutionality of the practice could be maintained no longer. But before I get to that, as Jackson's law clerk, E. Barrett Prettyman Jr. noted, and I believe he has been here as well, he noted in a memo to the justice, Jackson would have had to place considerably less emphasis upon the problems of enforcement and justification so that his argument in the final section of his opinion was not swallowed up by doubts and fears. And but I'm going to argue later that Jackson's attention to such difficulties contributed significantly to the strength of his opinion. Now, with regard to Jackson's rationale for ending segregation, he emphasized in the final section of his memorandum that the court in this case retained the long-standing principle that equal protection allows classifications that rest upon real, not upon feigned distinctions, and that have a rational relationship to the subject matter for which the classification is adopted. What the court does invalidate, however, according to Jackson, are classifications in education based upon race. Why? Jackson argued we are now able to see that the primary basis of these classifications is incorrect, namely, the assumption that there are differences between the black and the white races viewed as a whole, such as to warrant separate classification in educational facilities. Jackson conceded that he did not know whether this presumption was warranted in earlier times. When first liberated, he argued, African Americans had little opportunity to demonstrate their capacity for education or even for self-support. Jackson said he did not want to stigmatize as hateful or unintelligent the early assumption that black education presented problems that were elementary, special, and peculiar, and that the mass teaching of African Americans was an experiment not easily tied in with the education of pupils of more favored backgrounds. However, Jackson added, spectacular progress made by African Americans, and he characterized it as one of the swiftest and most dramatic advances in the annals of man, that this has enabled African Americans to outgrow and to overcome the presumption on which segregation was based. Now, in Jackson's words, the handicap of inheritance and environment has been too widely overcome today to warrant these earlier presumptions based on race alone. I do not say that every Negro everywhere is so advanced, nor would I know whether the proportion who have shown educational capacity is or is not in all sections similar. But it seems sufficiently general to require one to say that mere possession of colored blood, in whole or in part, no longer affords a reasonable basis for a classification for educational purposes, and that each individual must be rated on his own merit. The necessity for judicial action on this subject, Jackson concluded, thus arises from the doctrine which is already on our books. Right. Now, the fundamental difference between the opinions of Warren and Jackson was the challenge that Jackson posed to the underlying premise of segregation. Jackson's opinion, in other words, was predicated upon the accurate assumption that the primary justification for racial classifications was a belief in the inferiority of African Americans. In the latter part of the 19th century, individuals and groups, both Northern and Southern, whose views dominated public discourse, accepted the notion of black intellectual and moral infirmity. And these allegedly immutable racial distinctions were thought to necessitate and justify segregation in general to avoid the debilitation of the white race through intermixture, and the separation of the races for purposes of education in particular, because blacks supposedly could not benefit from the education afforded to whites. Jackson's bold decision to examine the sensitive issue of racial differences contrasted sharply with Warren's strategy of focusing on the harms that segregation caused. Jackson's approach, I believe, was superior because it would have been less vulnerable than was Warren's opinion to the attacks of segregationists, and more persuasive to the minds of those who had no interest in perpetuating this practice, but would insist that an exercise of judicial power be legitimate. Specifically, Jackson's argument concerning the unconstitutionality of segregation was less susceptible to the charge of judicial legislation than was Warren's rationale. Prior to Brown, the justices had never challenged the separate but equal standard itself. At most, they insisted that separate educational facilities be equal. By maintaining that separate schools could never be equal, Warren departed significantly from previous decisions. And Jackson realized that when judges overturn earlier rulings, they violate the social expectation that judges adhere to law. And he believed that the court should act to preserve its prestige by resting its decision upon a legal foundation. In other words, while the justices would reverse constitutional doctrine, that is, they would invalidate the notion of separate but equal, he argued that they should do so by employing the standard used in previous equal protection cases, namely, classifications between groups or individuals are allowable only if they reasonably relate to legislative purpose and are based upon real distinctions. And you should note that a common charge directed at Warren's opinion was that it blatantly ignored all law and precedent. Now, certainly Jackson would have been criticized for departing from the understanding that racial classifications in education are reasonable. However, my argument is that his approach enabled him to use language emphasizing continuity with previous rulings, and this was language that Warren could not employ, given his strategy. Another sense in which Jackson's argument was less susceptible to the charge of judicial legislation was that it did not rely upon extra legal materials. Specifically, conspicuously absent from Jackson's opinion were references to the sociological data that Warren mentioned in his opinion, ostensibly to demonstrate the harms of segregation. Now, I will concede that constitutional controversies are often bound up with empirical questions, and that such cases should be decided on the basis of facts derived from the most reliable sources. But the fact is that the public generally views law and social science as insular disciplines. That is, most people believe judges should merely interpret law, and judicial use of sociological data is oftentimes viewed as evidence of a policy-making judiciary. Indeed, many commentators viewed Warren's opinion and his use of sociological studies as proof of the political as opposed to the legal nature of the Brown decision. In fact, one respected journalist in the New York Times said that Warren's opinion read more like an expert paper on sociology than a Supreme Court opinion. In view of the fact that studies demonstrating the harmful effects of segregation were irrelevant to Jackson's holding, he had no reason to refer to that data. His contention that racial classifications in education were unreasonable did not depend upon whether segregation created a feeling of inferiority in black children. In his working papers for the case, Jackson expressed great concern over the court's use of sociological evidence and said he did not think that the court should employ this. Now, while Jackson based his decision upon an empirical proposition, that is, he was arguing that blacks are not inferior to whites, my point is he was not obligated to employ extra legal materials. Why not? Because there were no direct recent rulings examining the basis of racial classifications. Unlike Warren, who had to address recent rulings that accepted the possibility that separate facilities can be equal, Jackson could resort to a common sense discussion of changed presumptions and conditions, which necessitated a modification in constitutional doctrine. The basis of Jackson's holding was useful not only for the purpose of preserving the court's integrity. Jackson's argument also placed the right of the petitioners to equal protection of the laws on a secure foundation, a foundation more secure than that provided by the claim that segregation creates a feeling of inferiority in black children. And the efforts of segregationists to have Brown reversed revealed the shortcomings of Warren's approach. Segregation proponents accumulated evidence ostensibly demonstrating the preferability of segregated to integrated schools. They referred to the work of scholars such as A. James Gregor, who, using a very short-term perspective, argued that racial separation actually enhances the development of a healthy personality in the black child, I quote, by reducing the psychological pressure to which the child is subjected through contact with whites. Segregationists, I should note, were not the only persons to criticize the court's argument. Several scholars sympathetic to Brown doubted that the empirical basis of the court's holding had been demonstrated convincingly in the findings of social science. While the effect of segregation on the personalities of black children was a matter of some controversy, the overwhelming weight of scientific opinion supported and continues to support the view that all significant disparities in achievement between blacks and whites were traceable to environmental rather than sociological or biological, biological causes. When the court rendered Brown, and since then, scientific racism attracted little attention and virtually no support from the social science community. So Jackson's assumption that his declaration concerning the irrationality of segregation would withstand criticism or challenge, I think, was well-founded. Now, while the form of Jackson's memorandum would have stifled or at least blunted much of the criticism directed at the court's decision, I should note that his argument for ending segregation was vulnerable in ways that Warren's opinion was not. First, Jackson would have been criticized for ignoring the main argument that the respondents put forth before the Supreme Court in defense of segregated schools, namely that racial separation was essential to the avoidance of racial conflict in elementary and secondary schools. Second, Jackson's explicit challenge of the notion of racial inferiority would have made the court's opinion appear somewhat self-righteous. He held that the irrationality of segregation was apparent to all reasonable minds. And if you think about it, the flip side of that statement is that only unreasonable or morally deficient people continue to see any justification for racial classifications. Warren's opinion, of course, also drew attention to the moral deficiency of segregationists. He maintained that segregation causes permanent harm, and all of America knew where culpability lay. Nevertheless, the psychological damage segregation caused was not presented as a self-evident truth in Warren's opinion. Warren used social science data to demonstrate the existence of that harm. The infliction of this injury thus appeared less blameworthy than a belief in racial inferiority. Third, Jackson's opinion would have had the regrettable effect of subjecting African Americans to the demeaning and the superficial arguments of racists. Had the court's opinion struck at the roots of segregation, defenders of the practice would not have hesitated to defend the notion of immutable racial differences in intelligence. Warren's opinion, of course, avoided this problem because Warren made no observations about the underlying premises of segregation, having focused on the harms of the practice, in his opinion. Now, while the drawbacks associated exclusively with Jackson's memorandum would have warranted concern, these problems were surmountable, or were not as significant as the problems that Warren's opinion presented. First, Jackson could and should have noted, as Warren did in his opinion for the federal companion case to Brown, Bowling versus Sharp, that since 1944, the court had regarded racial classifications as suspect. What does that mean? Well, with suspect classifications, the burden is on the state to demonstrate the validity of the arguments supporting the classification. And mind you, none of the states involved in the litigation had demonstrated that desegregation was likely to result in racial conflict, to say nothing of the fact that the states had failed to prove the inferiority of African Americans. Second, Jackson minimized the accusatory or self-righteous tone of his opinion by discussing at some length, if you recall, the numerous legal considerations that appeared to support school segregation, and by noting how recent were the changed circumstances that rendered this practice unreasonable. Finally, arguments defending the notion of black intellectual and moral infirmity would have been voiced had the court employed Jackson's reasoning. And I think the court could have done nothing to prevent this. But it may be that significant progress toward racial equality in American society requires that racists be challenged to defend their baseless arguments. All right, so if I'm right, and Jackson's opinion afforded a more compelling strategy for securing the rights of the plaintiffs in Brown, I think it's reasonable to ask why the court did not adopt this approach. Interestingly, it appears that during the deliberations in Brown, Chief Justice Warren considered an argument for ending segregation similar to Jackson's. If you look at the conference notes for the justices, Warren initially intimated that the court should attack the underlying premise of segregation. Apparently, Warren's decision to drop this strategy was a function of his strong desire to secure unanimity. Several members of the court were Southerners, you recall. And as the conference notes of several of the justices reveal, Justice Reed reacted very strongly when Warren stated that the only justification for racial segregation was a belief in racial inferiority. So, while the form of Warren's opinion drew public criticism that Jackson's approach may have avoided, I would argue that the Chief Justice delivered something essential for the eventual success of a controversial ruling that Jackson would have been unable to furnish, and that is the force of a court speaking with one voice. Thank you.
For some questions?
Sure.
If Jackson died in 1954, this was rendered in May of 1954, really the last great decision of which Jackson was involved. If he had, and this was of course just a ruling on separate but equal, which said separate but equal is unconstitutional, the court decided not to figure out what the remedy was. So they decided to re-argue that in Brown versus Board 2, which is 1955.
That was actually, I think Jackson had something to do with that. He argued we should split these. Initially, he didn't want to do that, but he realized we're not going to be able to reach any consensus if we try to do both of these things at the same time. So
anyways, I want you to comment on that, and also, if he had stayed alive, would that second decision, the with all deliberate speed decision, been different?
I guess this is the sort of question on which I cannot be wrong, no matter what answer I give. So yeah, with respect to the decision to split the ruling about segregation and the remedy, if you look at the conference notes of the justices, Jackson initially said you can't do that. I mean, judges need to give a remedy for the rulings that they give. But after they deliberated on this, it became fairly clear that they were not going to have any consensus because the matter of implementation was such a sticky one. And so there was a point at which Jackson just threw up his hands in the notes. I forget, I think it was Justice Frankfurter, who uses exclamation points when he's recording what Jackson said. And Jackson essentially said, you know, let's just table this. And so they split the decision on segregation from the matter of remedy and decided to re-argue remedy. As far as what would have happened had Jackson been on there, my guess is that things would not have been that different. Jackson was willing to defer to his Southern colleagues. And he said he had actually, there's one point in the deliberations where he said he had not even really thought about racial matters all that much, the issue of segregation, because it was not a big deal in this part of the country. And what were the Southerners saying? Black in particular was scaring his colleagues tremendously by saying that you all have to be aware that there's going to be some pretty significant consequences. There's going to be enormous resistance and possibly violence. And so they ended up being reluctant to call for, to agree to Thurgood Marshall's demand that the implementation be essentially immediate. And they decided that we can't do that. And so they ended up with, as you know, the term with all deliberate speed, which Frankfurter proposed to the court. And there's a lot of scholarship now arguing whether this was a good idea or a bad idea. But I have to believe that Jackson would have gone along with the rest on that particular issue because of the implications of, I mean, they knew what they were doing was a profound decision that it was going to have an enormous impact upon the South.
Professor Hockett, Barrett Prettyman, when he was here, I think said that he was one of the people that talked to Jackson out of publishing this memorandum as a concurring opinion because he felt that there was too much reference to what was going on in the South and it would engender more resistance to the decision. Is that, what do you think Prettyman's argument, if I'm saying it correctly?
Yeah, I think it's a pretty powerful critique of Jackson. You could say Jackson's approach, you could criticize his approach for its radicalism. That is, its apparent lack of political savvy, because if you think about his rationale, Jackson's rationale, that segregation is basically reflective of a belief in racial inferiority, what that does is undercuts any form of racial segregation. And what the court was trying to do, what Warren was consciously trying to do with the Brown decision, was to focus specifically on the issue of education, right? So that they could say, well, we're only dealing with this narrow matter, and so all other aspects of segregation are untouched, at least at this point. How would I respond to that? Well, I actually think that's less of a damning criticism of Jackson's opinion than you might think. What happened after the Brown decision came down, and there were subsequent per curiam rulings in which the court invalidated segregation in all other aspects of life, not just education. And by the way, they kept citing the Brown decision for those rulings. If you look at what happened, segregation fell rather easily in every realm except education. And so it seems to me that as radical in its implications as Warren's strategy was, I think that education, the fact that they were focusing on education was what made it controversial. That was the most sensitive area of Southern American life at that time. So I wouldn't be I personally am not too hard on Jackson for the radicalism of his approach, because I think he knew this is we couldn't be more controversial than we are being in going after education.
A sense that one of the things the Supreme Court doesn't have is enforcement, and that there was a frustration that there really was no decisions after Brown versus Board 2, and the whole process of desegregation and what happened in the civil rights movement, all of that which spawned from Brown versus Board 2. Was there a frustration on the court that they didn't have a chance to clarify this, or did they just sort of step back and say, all right, whatever?
Well, they had plenty of opportunities initially, these per curiam rulings, but they purposely made them per curiams and just cited Brown. And I think it's, again, they wanted to avoid wading in, yet again, into this area too deeply. And so my guess is they were probably fairly grateful that they weren't going to be as controversial as they were in Brown again and again and again. I think what they had hoped, certainly Warren hoped, that the prestige of the court and the compelling nature of the ruling would have been taken up by the chief executive. And if you look at Warren's memoirs, he's really resentful of the way Eisenhower, in his mind, dropped the ball. And so I think what the court hoped was going to happen is that they would render the ruling and that the executive branch would take it and do the right thing. As we all know, Eisenhower was not interested in doing that. And the nation was, I think, really hurt by that. But yeah, I don't think that the court was looking forward to rendering yet another controversial ruling on that. Yes, sir.
One recent trend is segregation by gender today. Is that in conflict with anything?
Segregation by gender. That's an interesting question, because Jackson's approach would insist, okay, what are the reasons for segregating students on the basis of gender? And I mean, the Supreme Court has not treated gender as a suspect classification. It's kind of in this weird mid-level range where they say we're going to be not really suspicious of it, but kind of suspicious. We're not going to assume that it's okay, but we will not look really, really skeptically about it. And my suspicion is that educators who use if they segregate students on the basis of gender, they would not that'd be foolish to make the argument that it's based upon a sense of gender inferiority. But yeah, I suspect Jackson didn't think about this at all. But it is a really important, I think, an interesting question. What are the implications of this?
Inferiority is probably superiority.
Yes. In fact, I will take this opportunity to say that in my 17 years of teaching, that the students who have gone on and done extraordinarily well have overwhelmingly been women. In fact, I just started a lecture series where I'm bringing back my former students who have had great careers, and the first one was a woman who is just most remarkable, one of the most remarkable people I've ever met in my life. Having said that, though, I don't want to insult my own gender. The person I'm bringing back next year, currently, it's a he, and he's currently serving as Chief Justice Rehnquist's law clerk. So, yeah.
It occurred to me as you were speaking about segregation, what we did to the American Indians with their children, removing them totally from their family of origins and their culture. And what would we call that today? Would that be integration of some sort of strange twist?
What would we call the practice of separating children from their, besides utterly tragic? And,
tragic was probably the best. But they were moved into the schools, as we know, to try to
radically assimilate.
Yes.
Yeah. I'm at a loss for words, too. I mean, your point is an excellent one, which is in the matter of racial injustice, we oftentimes just go right over. We gloss over the injustices done to Native Americans. And yeah, I mean, it deserves a lot more attention, especially since you see in the news, even today, you know, the government, the incredible injustice done to the trust funds of Native Americans. But yes, I mean, the attempt to radically assimilate Native Americans, I mean, I think your point is it goes beyond injustice. And again, I'm not sure I could do it justice. But it is a racial injustice of a different degree.
Where are we today in the court system relative to precedent and the so-called judicial activism? I mean, what are you teaching in law school? What are the law review articles saying on this?
Mercifully, I'm not a law professor. I'm an undergraduate professor, so I dropped out of law school, in fact. But your question is?
Well, I mean, you know, we all hear about Roe v. Wade. We hear about judicial activism. I'm just wondering, what do you see in Brown against the Board of Education relative to today's situation with judicial activism, which is actually an issue in the election? Presidential election.
And it's a focus of the course in constitutional law that I'm teaching right now, because your question is basically, how should judges interpret the Constitution? You have a president who says that what he would like to do is appoint other justices like Clarence Thomas. What does that mean? Clarence Thomas is an originalist, meaning he argues the court should only follow the intentions, the subjective intentions of the framers. And not just Clarence Thomas, but the conservative approach to the judiciary in particular is heavily dominated by originalist justices. Now, Brown actually has an enormous impact on this debate, because as I tried to point out to my students, if you're serious about following original intent, you need to ask yourself, what are the implications of that? Well, you think about Brown versus Board of Education. According to originalist tenets, that is, if we're going to follow the original intent of the people who framed and ratified the 14th Amendment, in particular the Equal Protection Clause, you must ask as an originalist judge, did the framers of the 14th Amendment intend for African American and white children to attend the same schools? And I think that Jackson is actually right, that by originalist tenets, Brown is a patently illegitimate decision. So what does that tell us? What that tells us is, and even Robert Bork, who is one of the prime exponents of originalism, notes that this is a real problem for those who argue in favor of following original intent. Because if you have a theory of judicial review that cannot allow for what is quite possibly the greatest decision the court ever handed down, then that's a problem for the ethical implications of your theory. Because if they got it wrong, if the framers of the 14th Amendment got it wrong on that issue, then you have to ask yourself, well, did they get it right on other issues like women and sexual preference? Because I can assure you that they were not thinking of women's rights or the rights of homosexuals when they were deciding, or when they were framing and ratifying the 14th Amendment. So and what you have now is this really interesting attempt in the literature, in law reviews. I'm not a law professor, but I read a lot of law reviews. There's this really interesting, and I think just deeply flawed attempt to try to reconcile Brown with the subjective intentions of the framers of the 14th Amendment, but you just can't do it. I mean, you cannot. As Jackson conceded, there's overwhelming evidence that the framers of the 14th Amendment did not intend for African Americans and whites to go to school. Now, does that mean that all judges must therefore be non-originalists? I try to be as even-handed as I can in this when I teach my students. I say, you have to understand that every approach that you're going to take to constitutional interpretation is going to have certain advantages, but also some disadvantages. We just talked about the disadvantage associated with originalism, and it's a pretty big one. But if you're going to argue that, say, Ronald Dworkin, who's the foremost liberal constitutional theorist of the last century and the current century, that he's the way to go, you end up with problems there as well, because try as he might, Ronald Dworkin, I don't think, has been successful, even though I admire him, has not been successful in showing that his brand of constitutional interpretation, which is liberated from the original intentions, that it amounts to anything more than judges just going after their favorite personal political philosophy. And that's a problem in our political culture, because we do, and I think rightly, want judges to base their decisions upon some kind of law. So what I end up doing, and I'll do it here, I love doing this in class where I leave loose ends. And I say to students, okay, here are your options. Life is a series of decisions of least worst alternatives, and this is what we have to do in this sort of situation.
What I have to say is largely by way of commentary rather than asking a question. Although I studied constitutional law at the University of Michigan Law School under Professor Paul G. Clapper, I have not been a constitutional lawyer. I've been a small-town lawyer for over 50 years, and I'm one of the few living members of the Jamestown Bar Association that was present at the luncheon held after Robert Jackson's funeral at Moonbrook Country Club. And I met Chief Justice Warren and all the other surviving justices. And knowing what we know about Chief Justice Warren, isn't logical to assume or to expect that his opinion would be flavored by political aspects rather than a serious study of jurisprudence and background law. And by the same token, Justice Jackson, as we all know, was largely a self-made man and self-taught. And he, I'm sure, had a great deal more about constructing his opinions and the thought processes that went into them than Chief Justice Warren did. I suspect that, although I don't know, that Chief Justice Warren had a lot of his opinion written by his clerks and others.
Actually, he wrote that. Yeah, I have all the different drafts, all in Warren's handwriting. So
I didn't hear you.
Warren wrote that opinion. Yeah, and he had some editing done by.
Well, I haven't had the advantage of studying the opinion, but.
Yeah, it's an interesting question that you ask, and it's funny that you should ask that, because I talk about this in the manuscript that I've written that's under review right now. And your question is, do these justices, Warren and Jackson, come at these issues from different traditions? Do they have a different intellectual strategy for approaching these things. And I would say, yeah, there is something to that. I think Jackson, much more cerebral than Earl Warren.
That's my belief.
Right, but having said that, I'm not sure I'd characterize Warren's approach to Brown as political. I mean, well, I would agree with this, that he was keenly aware that he had to be concerned about how the opinion was received by the public, and that's why he ends up, he does everything possible to get a unanimous court, and I think, as I argue, this is why he ended up with the strategy that he did. But having acknowledged the differences between the two, at the end of this talk, remember I suggested that Warren initially proposed a similar, or at least implicitly proposed a similar strategy that Jackson used. And this is what I'm arguing in my book. I spend 2 chapters talking about Warren's approach to this. And I would argue what happened was that Warren was not initially focusing on the harms of segregation per se. Like Jackson, he became convinced of the arguments that were made before the court by the lawyers for the Legal Defense Fund. And their argument, if you get a chance, you should go look at the transcripts and the briefs that were submitted by the petitioners in this case, because they had some incredible scholars who contributed to this. C. Van Woodward, for example, was one of the brief writers for the Legal Defense Fund. And what they did, what the Legal Defense Fund did, was made this argument and kept hammering away at it that segregation is white supremacy. And that, I think, is what convinced Warren and Jackson, among others on the court, that this had to go. And this is another area of research for me where I try to answer the question, how is it that Brown went from being this incredibly controversial decision, not just from the perspective of segregationists, but from liberal constitutional scholars as well, how did it go from being so controversial to being a political icon? The reason is, I argue, that what happened was it wasn't because of what the court said in Brown, because today nobody pays attention really to what Warren argued in that case for the court. So why is it considered so great? Well, what happened was, I would argue primarily Birmingham in 1963. You remember all the images: fire hoses turned on, peaceful civil rights demonstrators, attack dogs, and and also the Little Rock Nine. Children going into school being spat upon simply because of their race. These images were sent across the nation. And after that point, after people saw these images, from that point on, it was no longer possible for the white South to say it's for the good of both races. It was pretty clear, it was patently obvious, actually, that it was a form of white supremacy. And so Jackson and Warren, I would argue, saw in 1953, when they were deliberating about this case, the real nature of segregation. They didn't use that rationale in the case, but that's ultimately why Brown versus Board of Education came to be regarded as a political icon in our culture, because though the court didn't say this in its opinion, what happens is people rewrite that case. And the way it's taught now is that this was the opening salvo in the attack on white supremacy. So.
Thank you very much.
Thank you.
I'd like to, again, thank the Jackson Center and Greg and Raleigh and Becky and all those for your support and sharing people like Professor Hockett with us. As I sat through today and listened to this group, it reminded me that the round table is at times actually a living classroom. And it was great to see the exchange between, I would characterize you as our students and the faculty member today. And that was, I think, meaningful, especially as we look at the kinds of things that Professor Hockett was talking about that to me seem to be so relevant yet today, which may be another significant piece of the history of that particular decision and case. That there's so many ways we can take what was said today and said at that time and apply that to what we're dealing with in today's world. Maybe more of an international scale today, but certainly apply it. Also, I'd like to take a moment to just recognize the reason we're all here. And a number of our JCC students are with us today, and they've taken a very polite table in the corner. Could you stand and let us recognize some of our students? How the JCC students? Thank you, guys. It's always good for us to remind ourselves what it's all about, and having our students with us is always a pleasure. Speaking of JCC students and programs, this Friday, the JCC production of the musical Hair will open. For those, anyone that looks a lot like me, you will remember the original. So we think this is going to be a great production. Encourage you all to come out and see our production of Hair. Thank you for coming, and it's always a pleasure to have you here at the round table.
For the invitation.